Elizabeth Arden built a 20th century empire on cosmetics and beauty treatments. Expanding her operations after the Second World War, she hired a new sales manager. Their subsequent dispute resulted in the contracts case Crabtree versus Elizabeth Arden Sales Corporation. In 1947, Nate Crabtree entered negotiations with Elizabeth Arden's cosmetic company to take a job as a sales manager. Crabtree requested a 3-year contract at $25,000 per year. He insisted that he needed a contract for a definite term because he'd be giving up secure employment to venture into a completely new field. Arden, the corporation's president, said she could offer a 2-year contract with an annual salary of $20,000 for the first 6 months, $25,000 for the second 6 months, and $30,000 for the second year. Crabtree replied that this offer was interesting. Arden had her secretary write up these salary provisions on a telephone order blank. This unsigned memorandum was entitled, quote, "Employment Agreement," unquote, and it contained Arden's name, the name of the company's general manager, Crabtree's name, and the words, quote, 2 years to make good, unquote. Crabtree accepted this offer. When Crabtree reported to work, the general manager made up a payroll change card that listed his salary as Arden had described it. The general manager initialed this card. After 6 months, Crabtree's salary was raised to $25,000. 6 months later, however, Crabtree's expected raise didn't materialize. The comptroller promised to straighten things out and created another payroll card noting a salary increase from $25,000 to $30,000 per contractual agreement with Arden. The comptroller signed this card. Arden refused to approve this raise. Crabtree quit his job and sued Arden for breach of contract. At trial, Arden denied that she had entered into a 2-year employment contract with Crabtree and that even if she had, the statute of frauds made it void. The trial court found for Crabtree and awarded him $14,000 in damages. The appellate division affirmed. Arden appealed to the Court of Appeals of New York.